Turn that damn camera off right now and show me some ID.
The camera stays on, and I need to know why you stopped me first.
I don't need a reason to stop anyone in this neighborhood, sweetheart.
Actually, you need reasonable suspicion under the Fourth Amendment.
But don't get smart with me. I've been doing this since before you were...
It was a Sunday morning, and Dominique Perryman was on her way to church. She had woken up earlier than usual, had spent extra time getting ready, was wearing her best dress, and had left home with enough time to arrive before the service began. It was the kind of morning that should have had no story to tell. The kind of morning that passes and fades into memory as just another ordinary Sunday. But when she turned the corner of the street where she had lived for the past 6 years and saw the flashing lights in her rearview mirror, something in her stomach recognized it before her brain had time to process it. She pulled over. She lowered the window, and what appeared on the other side of that window was a white police officer with the expression of someone who had already decided how that conversation was going to end before it had even begun. What followed over the next 23 minutes was captured in full by Dominique's phone, which she had discreetly positioned on the dashboard before the officer reached the window. She knew how to do that, not because she was an activist, not because she had a history of conflicts with police, but because she was a second-grade detective with the Franklin County Police Department in Ohio, with 12 years of service, a specialization in crimes against persons, and a record that included more than 140 successful arrests over the previous 3 years. She knew traffic stop protocols better than most academy instructors. She knew exactly what an officer should and should not do in that type of situation. And within the first 30 seconds of that stop, she already knew that what was happening had nothing to do with traffic. The image the video captured, a uniformed officer leaning over her car window, hand positioned near the equipment on his belt, mouth open in a tone that was not a question but an imposition, circulated across the country in the weeks that followed. But before arriving at the moment when that video became central evidence in a federal criminal case, there is a story that needs to be told from the beginning. About who that officer was, what he had done before that Sunday morning, and why the system that should have contained him had failed repeatedly for years before Dominique Perryman crossed his path. Before we go any further, I want to ask you something directly. Subscribe to the channel right now and drop a comment with one word that describes what you feel when you watch a video like this. It doesn't need to be elaborate. One word is enough, because stories like this exist in a space where it is very easy to consume and move on. And what I want is for you to stay, to follow through to the end. Because this particular case has an outcome that most stories like this never have, and you need to see how it got there. The officer who appears in that video was named Craig Welton. He had 14 years in the Reynoldsburg Police Department, a mid-size city in the metropolitan area of Columbus, Ohio. 14 years is enough time to build a career, to earn institutional respect, to accumulate the kind of internal political capital that protects an officer when complaints arrive. And the complaints had arrived. Not one, not two. Public records obtained during the legal process that followed the incident with Dominique revealed that Welton had accumulated 11 formal complaints over the course of his career, 7 of which involved allegations of racially discriminatory behavior during traffic stops. Of the 11, 2 had resulted in verbal warnings. The other 9 had been internally archived with no disciplinary action. Welton had learned, over 14 years, that there was a very high ceiling for what he could do without real consequences. That Sunday morning, he discovered the ceiling had disappeared. The neighborhood where Dominique was stopped was the same one where she lived, where she shopped, where she dropped her children off at school during the week. It was a neighborhood she knew by heart, where neighbors knew her by name, where she had built an entire life. There was nothing unusual about the way she was driving, the condition of her vehicle, her speed, or the lane she was in. The dash cam footage shows this clearly. The camera records completely normal, driving in the seconds before Welton's lights appear in the rearview mirror. There was no infraction. There was no legitimate pretext. There was a police officer who saw a car being driven by a black woman in a neighborhood he had patrolled for years, and decided that was reason enough to act. Craig Welton had arrived at work that Sunday morning 40 minutes early. That detail, apparently irrelevant, came to light during subsequent investigations and was cited by forensic psychologists hired by the prosecution as part of a behavioral pattern that had been documented in previous incidents. Welton had a habit of arriving early on days when he was in the mood to create problems. That was how colleagues who later testified against him described it. with the uncomfortable precision of people who had observed something for years without having the right words to name it. He would arrive early, take the patrol car alone, and head out into the neighborhood with an energy that others had learned to recognize. It was not professional enthusiasm. It was something else. It was the particular disposition of someone who was looking for a specific situation and knew it was only a matter of time before finding it. He had made 3 other stops that morning before pulling over. Dominique's car. Dispatch system records showed this with time-stamp precision. The first had been a black man driving a pickup truck toward the city's commercial district. Welton had stopped him, spent 19 minutes asking questions without issuing any infraction, and released him with no formal record. The second had been a Latina woman in a vehicle with an out-of-county plate. Same dynamic. Prolonged stop, questions with no apparent foundation, release with no documented infraction. The third had been a young black man on a bicycle, stopped on the shoulder of a road where cyclists had every right to be. Welton had stayed with him for 11 minutes before moving on. 3 stops in less than 2 hours, 3 people of color, no documented infraction in any of them. When Dominique's attorneys presented these records during the proceedings, the federal prosecutor described that morning as a pattern of hunting, not patrolling. When Welton's lights appeared in Dominique's rear view mirror, she did what any person trained in stop procedures would do. She pulled over immediately, in a well-lit location, with enough space for the officer to approach safely. There was no hesitation, no evasive maneuver, nothing that could be interpreted as lack of cooperation. She placed her hands visibly on the steering wheel and waited. In the interval between pulling over and the officer reaching the window, which lasted approximately 45 seconds, she picked up her phone from the cup holder with a deliberate movement and rested it on the dashboard, camera facing the driver's window. It was not the first time she had done this. It was a personal protocol she had developed over years, not out of paranoia, but for the same reason any law enforcement professional documents potentially problematic interactions. Because evidence is the difference between what happened and what someone decides to say happened. Welton arrived at the window with the posture the video captured, and that became the image most associated with the case in the weeks that followed. Body leaning over the window opening, right hand resting on the equipment on his belt, expression that mixed performative authority with something that people who analyzed the video described consistently as contempt. He did not introduce himself. He did not state the reason for the stop, which is basic mandatory protocol in virtually every police department in the country. He did not ask if Dominique was all right. He immediately began asking questions about where she was going, where she had come from, whether the car was hers, whether she had been drinking. It was a sequence of questions that corresponded to no known traffic infraction. You do not ask someone if they have been drinking at 9:30 on a Sunday morning without any observational basis for it, such as erratic driving behavior or the smell of alcohol. It was a fishing expedition, an attempt to find something during this conversation that would retroactively justify the stop that had already happened without justification. Dominique answered each question with precision and economy of words. She was going to church. She had left from home on the parallel street. The car was hers, registered in her name. She had not consumed alcohol. Her answers gave Welton nothing to work with, and the video captures the moment he realizes this. A pause of perhaps 2 seconds where he looks into the car, then at the document Dominique had handed over, then back at her, as if recalculating. It was in that pause that he committed the first serious legal mistake. He said, with his body camera running and Dominique's phone recording, that he had stopped her car because she did not look like she belonged in that neighborhood. He did not say there had been an infraction. He did not say driving behavior had generated suspicion. He said she did not look like she belonged there, in a neighborhood where she had lived for 6 years, on a street less than 1 kilometer from her own home. Dominique's expression at the moment. Welton said, that is one of the most discussed elements by those who analyze the video in detail. There was no explosion, no visible emotional reaction, nothing Welton could use to escalate the situation. There was a very slight shift in posture, almost imperceptible, the kind that happens when a person who already suspected something receives confirmation that their suspicion was correct. She had entered that stop as a detective, and she had just received, from the officer's own mouth with the camera running, the evidence that made the case legally incontestable before it had even ended. What happened in the minutes following that statement, the statement about her not looking like she belonged in the neighborhood, was where the stop crossed from administrative misconduct into criminal territory. Welton did not back down. He either did not grasp the weight of what he had said, or if he did, he calculated that there were not enough consequences to justify changing course. He ordered Dominique to step out of the car. There was no legal foundation for that. An order to exit the vehicle during a traffic stop requires the officer to have reasonable suspicion that there is a danger to their safety, or that there is evidence of a crime inside the vehicle. There was neither. The video itself documented that. Dominique was cooperative, hands visible, with no behavior that could be interpreted as a threat. Welton asked her to get out because it was the next step in the escalation he had initiated, not because there was any legal justification for the request. Dominique got out of the car. She made that decision consciously and deliberately, not because she was required to, but because she knew every second of that interaction was being recorded, and that her documented cooperation would make each of Welton's actions even more indefensible in the legal process she was already mentally constructing as it happened. When she stepped out of the vehicle, Welton instructed her to face the car with her hands resting on the hood. It was a search position, the kind of positioning used when there is suspicion that a person is armed or represents an immediate danger. Dominique Perryman was wearing a Sunday dress on her way to church. There was absolutely nothing in that scene that justified that positioning, but she complied. She faced her own car, hands on the hood, on a Sunday morning, on the street where she lived, being treated as a suspect for something Welton was unable to name because it did not exist. It was at that moment that one of Dominique's neighbors, a woman named Patricia Okonkwo, stepped out of her house to put something in the mailbox and saw the scene. Patricia was 63 years old, had lived on that street for 21 years, and had known Dominique since she had moved into the neighborhood. She stood on the sidewalk for a few seconds, processing what she was seeing. The neighbors she knew by name, whose children she had watched grow up, standing facing her own car with her hands on the hood, while a police officer circled around her. Patricia went back inside immediately and picked up her own phone. She did not call the emergency number. She called directly to the non-emergency line of the police department and reported what she was witnessing: a woman being detained without apparent reason in front of her own home. That call was logged with a timestamp and later became part of the body of evidence in the case. Welton spent the next 7 minutes circling around Dominique's car, looking through the windows, opening and closing the trunk, with the permission she had tacitly granted by stepping out of the vehicle without protest. Another element that defense attorneys would later attempt to use, and that Dominique's attorneys neutralized by arguing that cooperation under coercion does not constitute legal consent. He found nothing. Of course he did not, because there was nothing to find. The car was clean, registered, insured, with no irregularity of any kind. When Welton finished circling the vehicle and returned to where Dominique was standing, the video captures a moment that prosecutors would later cite repeatedly in hearings as the point where administrative misconduct definitively became a crime. Welton grabbed Dominique's wrist with his hand, without warning, without justification, without any context that made that physical contact legally defensible, and repositioned her so that she was facing sideways relative to the car. It was assault, simple, documented, indefensible. Dominique did not react physically. The restraint she demonstrated in that moment, watching the video, is of a quality that goes beyond training. It is the kind of control that comes from understanding, at a visceral level, that any physical reaction on her part in that moment, however justified, would be used to reframe the entire narrative. She stayed still, she breathed, and she said in a calm voice fully audible on the recording that he had just committed physical assault against a detective from the county police department and that the video had recorded everything. Welton stepped back one pace. His body camera recorded the moment. Dominique's phone on the dashboard recorded the moment. And Patricia Okonkwo, from the sidewalk across the street, was recording too. What happened immediately after Dominique's words was as revealing as everything that had come before. Welton did not apologize. He did not end the stop. He did not call for supervision. He stood in silence for a few seconds, then returned to Dominique's car window, picked up the driver's license that had remained on the seat, handed it back to her, and said she was free to go. No explanation, no formal record of the stop. No document indicating that contact had occurred at all. It was as though he expected Dominique to simply take the license, get in the car, and drive away. That the implicit threat of everything that had happened in the last 23 minutes would be enough to ensure her silence. It was the same bet he had made 11 times before, with 11 complaints that had been filed away without consequences. It was a bet he had won 11 times. This time, he had lost before he even knew he was playing. Dominique Perryman did not go to church that Sunday. She got in the car, waited for Welton to move away, and sat there for a few minutes with the engine running and her hands on the steering wheel. Not because she was in collapse. She would describe that moment later in interviews as a period of deliberate organization, not emotional paralysis. She was taking inventory, mentally checking every element of what had happened, every word that had been said, every action that had been taken, in the exact order in which it had occurred, with the precision of an investigator who knew that the quality of immediate memory was a resource that degraded with time and needed to be preserved while it was still sharp. When she finished that process, she picked up the phone from the dashboard, verified that the recording was intact, saved the file in 3 different locations, and sent a text message to her direct supervisor's personal number. The message had 4 words: "I need to talk now." Dominique's supervisor was Detective Chief Marcus Alley, a man with 26 years of service who had supervised Dominique for the previous 4 years and who, by all available accounts, held for her the kind of professional respect that is built over years of working together on difficult cases. He called back in less than 3 minutes. Dominique described what had happened with the same precision she had used to organize the information in her own mind. Chronological, factual, without emotional embellishments that could be used to question the objectivity of the account. When she finished, Alley was silent for a moment. Then he said she should come directly to the department, not touch anything in the car, and that he would be there when she arrived. He also said something that Dominique repeated in every interview she gave about the case. He said this was not going to disappear and that he was going to personally make sure of that. Dominique's arrival at the department that afternoon triggered a series of procedures that the Reynoldsburg Police Department had clearly not anticipated when Craig Welton went out to patrol that morning. Because Dominique was not merely a victim with a video, she was a colleague within the same system. A detective from another department who had been stopped, humiliated, and physically assaulted by an officer while she was off duty and on her way to church. That created an institutional problem of a completely different nature from an ordinary civil complaint. There were implications for interdepartmental relations. There was the question of the credibility of testimony from a witness who was herself a law enforcement officer. And there was the video, which Marcus Alley watched 3 times in a row in a closed room before saying anything to anyone. What Alley did next was what defined the trajectory of the case in a way that Welton and the Reynoldsburg department could not have anticipated. Rather than routing the complaint through normal internal channels, the same channels that had archived 11 previous complaints against Welton without consequences, Alley went directly to the Franklin County Prosecutor's office. Not a phone call. He went in person, that same Sunday afternoon, with a copy of the video on a USB drive and a 3-page written account that Dominique had dictated while he wrote. The on-call prosecutor who received him was a woman named Andrea Voss, who had 15 years of experience in crimes against persons and who, according to accounts from those present, watched the video once, closed the laptop, and asked Alley whether the victim was willing to cooperate fully with a criminal investigation. When Alley said yes, Voss said she would open a formal investigation the following morning. The investigation that followed lasted 6 weeks and was conducted with a level of secrecy that the Reynoldsburg department itself was not informed of its existence until it was already at an advanced stage. This was deliberate. One of the prosecution's first decisions had been not to notify Welton's department until the evidence was completely preserved and the initial testimonies collected, precisely to prevent any internal institutional protection process from interfering with the evidentiary material. Investigators from the prosecutor's office obtained the body camera recordings from Welton's other 3 stops that morning, the ones that had preceded the stop of Dominique. They obtained dispatch records showing the pattern of stops without documented infractions. They collected testimony from 4 of Welton's colleagues who, when confronted with the evidence and informed they were under legal obligation to respond truthfully, provided accounts that painted a consistent portrait of an officer whose behavior had been problematic for years, and whose complaints had been systematically minimized by a supervisory chain that prioritized internal cohesion over accountability. The most devastating testimony did not come from a colleague of Welton's or from one of the previous victims the investigators had managed to locate. It came from Welton's own immediate supervisor, a sergeant named Donald Pruitt, who had signed off on the archiving of 6 of the 11 previous complaints. When confronted with the evidence and informed that the investigation had found documentation that he had been warned about Welton's behavior by other colleagues on at least 3 separate occasions before any formal complaint had been filed, Pruitt made a decision that his attorneys later described as the biggest mistake of his career. Instead of invoking his right to remain silent, he began to talk. And what he said over the following 2 hours not only confirmed the pattern of institutional protection the prosecution was trying to document, it provided details the prosecution had not yet found, and that expanded the scope of the investigation in a way no one had anticipated when everything had begun with a traffic stop on a Sunday morning. What Donald Pruitt revealed in those 2 hours of testimony transformed what had begun as an investigation of individual misconduct into an investigation of institutional conspiracy. He described an informal but deliberate system within the Reynoldsburg Police Department where complaints against certain officers, specifically officers with years of service, with established relationships with department leadership, and with the kind of case closure record that made their presence institutionally valuable, were managed in ways designed to minimize formal consequences. It was not a system written down anywhere. There were no memos, no explicit guidelines, nothing an external auditor could find in a document review. It was a culture transmitted through informal conversations, through verbal guidance on how to document complaints in ways that reduced their apparent severity, through decisions made in off-agenda meetings that left no trace in the department's official records. Pruitt described specifically 3 episodes involving Welton that he had personally handled. In the first, 2 years before the incident with Dominique, a black man had filed a formal complaint describing an almost identical stop, pulled over without infraction, kept for more than 20 minutes, subjected to baseless questions, and released without any record. The man had recorded part of the interaction on his phone, but the video quality was poor and the audio was partially inaudible. Pruitt admitted that he had advised the man during the complaint phase to consider whether he was certain of what he had seen, had suggested there might be a misunderstanding about police procedures, and had framed the complaint in the internal records in a way that classified it as a dispute of interpretation rather than an allegation of discrimination. The complaint had been archived within 3 weeks. In the second episode, 18 months before the incident with Dominique, a Latina woman had filed a complaint alleging that Welton had made comments about her appearance and origins during a traffic stop. There was a witness. The woman's teenage son had been in the passenger seat throughout the interaction. Pruitt had interviewed the boy separately from his mother, without the presence of an adult guardian other than the witness himself, which was a violation of departmental protocol for interviews with minors. During that interview, according to Pruitt himself in the deposition, he had framed the questions in a way that suggested the boy might be confusing the officer's tone with ordinary rudeness rather than intentional discrimination. The complaint had been archived within 2 weeks. The third episode was the most serious of all and involved an allegation of disproportionate physical force that had been completely excluded from the department's formal records. Not archived as unfounded, but simply not recorded as having existed at all. Prosecutor Andrea Voss, upon receiving Pruitt's testimony, made a decision that expanded the scope of the charges in a way the Reynoldsburg Department had not anticipated when the case had begun. She added Pruitt as a secondary defendant in the criminal charges, not as a collaborative witness. And she based that decision on a legal doctrine that is rarely applied in police misconduct cases, but which, when applied, has devastating consequences for everyone involved. The doctrine of liability through deliberate omission, which establishes criminal responsibility for supervisors who, having knowledge of a pattern of criminal conduct by a subordinate, take active steps to prevent that pattern from being investigated or punished. It was not negligence, it was complicity. And Pruitt's 2 hours of testimony had provided the prosecution with exactly what it needed to sustain that argument before a jury. The formal charges against Craig Welton were filed 53 days after the incident in the Columbus residential, Neighborhood, there were 6 charges in total. Discriminatory stop with racial motivation, which was a crime under Ohio state legislation, reformed following a series of documented racial profiling cases in the state in previous years. Physical assault against a public safety officer, which carried an aggravating factor because Dominique was a law enforcement officer, even while off duty. Abuse of authority, falsification of public record, for the deliberate absence of any documentation of that stop in department records. Obstruction of justice related to the way Welton had attempted to end the interaction without leaving a trace after Dominique mentioned the video. And the 6th charge, the one that transformed the case from administrative to definitively and irreversibly criminal, second-degree kidnapping, because detaining a person by force without legal cause constitutes unlawful deprivation of liberty under the Ohio Penal Code, regardless of how long the detention lasted. When the charges were made public, the Reynoldsburg Department issued a statement saying Welton had been suspended without pay pending the conclusion of the legal process. It was a late defensive response, accompanied by a series of statements from department attorneys, attempting to establish distance between the institution and the individual officer's actions. Exactly the kind of dissociation that Pruitt's inclusion as a defendant made legally unsustainable. Because if a supervisor had actively protected Welton from consequences for years, the institution could not claim that Welton's actions were individual and isolated. The chain of responsibility went up, and the prosecution was determined to follow that chain wherever it led. Craig Welton's trial began on a Monday in March, 8 months after that Sunday when he had stopped Dominique Perryman's car in a residential neighborhood of Columbus. The courtroom was full. Not because there was a crowd of protesters or because the case had become a media spectacle in the most superficial sense of the word, but because there was an unusual number of people with a direct stake in the outcome. Previous victims the investigators had located, colleagues of Dominique from the Franklin County Department, representatives of civil rights organizations that had followed the case since the charges were made public, and a significant number of residents from the neighborhood where the stop had occurred, including Patricia Okonkwo, who had reserved a seat in the front row and who was present on each of the 11 days of trial without exception. Welton's defense strategy had been built on 3 pillars that his attorneys probably knew were fragile, but that were the only ones available given the quality of the evidence. The first pillar was to question the chain of custody of the recordings, to attempt to establish that there was a technical possibility that the video from Dominique's phone had been edited or manipulated between the moment of recording and the moment it was presented as evidence. That line of argument was destroyed in the second hearing, when the prosecution's technical experts presented forensic analysis of the video file that verified its integrity frame by frame, confirming there was no evidence of editing or manipulation of any kind. The second pillar was to argue that the order to exit the vehicle had been justified by security elements not visible in the video, but that Welton had perceived in person. That argument collapsed under cross-examination when the prosecuting attorney asked Welton specifically what security elements he had perceived, and the answers were so vague and internally inconsistent that the jury itself was observed exchanging glances during the testimony. The third pillar was the most desperate of the 3 and revealed just how short of real options the defense had run. Welton's attorneys attempted to argue that the physical contact, the assault for which he had been charged, had been an involuntary gesture, a positioning adjustment necessary for the safety of the procedure, not an intentional assault. That argument needed to survive the video. It did not. Prosecutor Andrea Voss, during closing arguments, paused the video on the exact frame in which Welton's hand grabbed Dominique's wrist, and left that image frozen on the screen for 27 seconds of complete silence before saying anything. When she spoke, she said only that the jury had seen what they had seen, that no verbal explanation could undo what was documented in that frame, and that the question before them was simple, whether that was or was not the definition of unprovoked physical assault against a citizen, who was cooperating fully with a stop that should never have happened. The jury deliberated for 2 days, not because there was doubt about the outcome, but because there were 6 separate charges, and the jury foreperson was a meticulous woman who insisted that each charge be analyzed individually with specific reference to the corresponding evidence before any vote was conducted. When they returned with the verdict, Craig Welton was found guilty on all 6 charges. The The room fell silent for a moment after the foreperson finished reading. Then Patricia Okonkwo, in the front row, put her hand over her face, and Dominique, seated beside her attorneys, remained completely still for a few seconds before briefly closing her eyes and opening them again with the expression that people who were present later described not as relief, not as triumph, but as the face of someone who had carried something very heavy for a very long time and had just been given permission to set it down. And sentence was handed down 6 weeks after the verdict. The judge who presided over the case was known for sentences that balanced punishment with proportionality, and there was a genuine expectation that Welton would receive something at the lower end of the range permitted by the charges. That expectation was quickly revised when the judge began reading the sentence. He spoke for 42 minutes before arriving at the number. He spoke about what the case represented in terms of abuse of public trust. He spoke about the pattern of 11 archived complaints and what that said about the institutional complicity that had allowed Welton to continue operating without consequences. He spoke about the specific impact on Dominique Perryman, not just the trauma of the incident itself, but what it means for a woman who dedicated her career to serving and protecting to be treated as a suspect by the very system to which she had devoted 12 years of her life. And then he arrived at the number. 5 years in state prison, with no possibility of early release in the first 30 months, followed by 3 years of supervised parole, immediate and permanent dismissal from the position, with irrevocable revocation of police certification in the state of Ohio. Donald Pruitt, prosecuted separately, received 18 months in prison and dismissal under the same conditions. Dominique Perryman gave a single press conference after the sentencing, outside the courthouse, with Marcus Alley by her side. She spoke for less than 5 minutes. There was no anger in those words, no performative victory, nothing that sounded like celebration of another person's suffering. There was clarity. She said there were 2 stories this case told simultaneously, and that it was important not to confuse one with the other. The first was the story of what had happened to her. A woman on her way to church on a Sunday, stopped without reason, humiliated on her own street, who had fought for what? Was right because she had the means to do so. The second was the story of all the people who had gone through something similar with Welton before her, whose complaints had been archived, whose names had never appeared in a newspaper headline, and who had not received any verdict in a courtroom that day. She said what had happened in that courtroom was justice for her, but that real justice meant the system that had protected Welton for 14 years should never function that way for anyone again. And that part, the systemic change, the real reform, the guarantee that the next 11 complaints would not be silently archived, that part had not yet happened. That part was still to come.